briefs are just now coming in from the various parties. Now, this prediction of mine and this view of mine probably does not reflect the consensus view, at least as reflected in the press, nor probably the view of most legal scholars that have looked at the law. And I think most of them look to what they see as a trend in Supreme Court cases over the last 10, 15 years in looking very strictly at separation of powers issues. And Congress has not fared very well in these cases. The first of these back in '74 was a case called Buckley v. Vallejo, and involved the validity of the Federal Election Commission. There you had an appointment power question. You had a commission that had authority over the public financing of elections. It had rulemaking authority, had significant administrative authority with respect to the eligibility of candidates for office for funds and the propriety of campaigns and that kind of thing. And the original version of that law provided that the House and Senate would appoint certain members of that Federal Election Commission. They weren't the sole appointing powers, but they did have a appointing role in the Federal Election Commission, and the court held that that was invalid under the Constitution. That the Article 2 of the Constitution that provides for appointments to office, appointments to public office, only contemplates the involvement of the executive and in some instances the courts in the appointment of officials, and that there was no place for Congress in appointing officials that perform executive administrative functions, significant functions under public law. So the court struck that down, forcing Congress to later amend the law. The second key case, which you've probably all heard of, is the Chadha case, the legislative veto case. And in that case, the court essentially held that once Congress delegates authority to executive officials, it cannot then influence the exercise of that authority or take some of that authority away by means short of passing another law. In other words, we had numerous provisions in the law that subjected various executive actions or various agency rulemakings to one-house vetoes, two-house vetoes, even committee vetoes. In other words, a committee could disapprove of a rule and the rule would not go into effect. The court said that violated the specific provisions in the Constitution that outlined very specifically how laws are to be passed. And it in essence said that if Congress wants to influence the actions of third parties outside the internal congressional sphere, it has to pass a law to do it. It cannot do it by means of action of one house or one committee. The third case, the final case, is the Marathon Pipeline case. That case involved the legitimacy of the bankruptcy judge system. There, Congress created a cadre of judges that would rule on various federal bankruptcy issues and also related state bankruptcy issues. But these judges had limited terms. I believe there were 14 or 15-year terms. And the court said that that was unconstitutional because it violated another specific provision in the Constitution, that is Article 3 of the Constitution, that provided that judges, those with persons with adjudicatory functions, must enjoy life tenure and they cannot be threatened with any diminution in their salary. The framers putting those provisions in the Constitution to protect the independence of judges. And the court held that therefore you cannot create a system of bankruptcy judges which did not enjoy the protections of Article 3, that is the life term and subject to statutory salary reductions. And I think most people that predict that the court will strike down Gramm-Rudman see in Gramm-Rudman similar problems to the explicit constitutional provision. In Gramm-Rudman, there really is no violation of a specific constitutional provision. It's a delegation of authority that is to be judged under normal delegation standards, but it doesn't violate a specific constitutional provisions like the other cases involved. And I think really this feeling that the court's going to strike down Gramm-Rudman flows more from a gut feeling that this is so unprecedented a delegation of authority, which is indeed true. The scope is so widespread, and it's such an unusual type of law for Congress to pass, it must be unconstitutional. There must be something wrong with it. And maybe there's a little bit of wish fulfillment in there also, but I think if you look closely at the law and if you look closely at the precedents, the Supreme Court will eventually uphold Gramm-Rudman.
The obvious purpose of the Gramm-Rudman bill was to try to make a decision which is automatic, and, so that congressmen can't be blamed for it and so forth. Why couldn't they set up a robot programmed to make its decision if certain things occur?
Well, that's a good question. If you look at the report of OMB and CBO on the sequestrations that was in the Federal Register running for hundreds of pages, it does look like a robot did it, because all it is a computer printout, which sort of bespeaks the fact that the process involved here is really one of fact-finding, plugging in numbers, and coming out with a formula.
I have another question. There is one decision that most of us here are aware of, affecting government economic policy, which is made by a private organization. That is the National Bureau of Economic Research, decides when there's a recession, and that is used as a basis for all sorts of activities, I presume, on the part of the administrative offices concerning unemployment compensation, Social Security, and other things. Or am I wrong about that?
I don't know about that specific situation, but you recall when I spoke that the Department of Justice is making these kinds of arguments in many different contexts, and that is one context in which they're making it. They're challenging all these kinds of arrangements that Congress may place in various laws, whereby private or quasi-public or other kinds of entities are given some administrative authority, some authority that is binding on an executive official that has impact on third parties. The Department has been consistent in challenging those kinds of arrangements. That you cannot have those kinds of hybrid arrangements in a three-branch system of government. Now, I don't know about your specific situation. I don't know how binding these things are, whether they're just something that's to be taken into consideration. But, for instance, in the securities context, there are private groups that have certain disciplinary controls over security dealers that, in some respect, are binding on third parties. And they are private groups that are exercising significant functions.
Yeah, I was just going to follow up on your answer before. And you said if Congress wanted to, they could just take away their power to remove the Comptroller General. But I mean, is that at first that seems like a fairly easy thing to do? But then isn't GAO in essence equivalent to OMB, and there was this tremendous distrust of OMB, so that I would think they might be very hesitant to do that.
They would. I think they are very hesitant to at least destroy the illusion or the appearance that GAO is Congress's man. I think that is an illusion. If you look at all the authority the Comptroller General has, I don't think he is an agent of Congress. And again, that's probably heresy for me to say that, but I think you're right. That would have political overtones. That would be difficult politically for Congress to do. Even though, as I say, that removal provision did not figure significantly in the decision to give the Comptroller General the duties that were given it under Gramm-Rudman. As a matter of fact, Congress thought at the time that by putting the Comptroller General in there, they were curing any constitutional problems they might have, because CBO was involved, who's clearly a congressional entity. And Congress felt that the Comptroller General's presence cured those problems because the Comptroller General was an appointee of the President. And I think there's much substance to that.
Doesn't it argue that the GAO is a congressional agency, that the fact that congressmen can get the same kind of services from GAO that they can get from Congressional Research Service and so on without any reference to the President?
That's a very...
that's not true for...
Well, that's a very interesting point. That's one reason why they might not want to take out the removal clause, but you have a problem. If the Supreme Court upholds Gramm-Rudman on the grounds that I think it will, I think the necessary premise is that the Comptroller General is essentially an executive officer. So I think it may raise a very serious question whether GAO can, in effect, do the bidding of a committee of Congress on the committee's own behest and that kind of thing. I think that it would really cause a re-examination of the various roles that the Comptroller General now performs.
Just on that, I mean, you seem to think it was unlikely, but I mean, is it even possible that the Supreme Court could take a very broad view and just strike down, in essence, all of these independent...
It is possible, and that's what my discussion of the sort of trend that I saw in the Buckley-Chadha marathon cases might portend. They might take a broad view. I mean, they took the broadest possible view in the Chadha case and, in effect, struck down every legislative veto on the books, where in a case that they could have decided on much narrower grounds if they wanted to. So that general trend might indeed portend a hard look at Gramm-Rudman. Yes, there's no doubt about that.
I mean, the Fed would be out of business, or what would happen?
Well, not immediately, obviously, but I mean, depending on how broad they enunciate their principle about three strict branches and how far Congress can go in insulating an officer from presidential control, you might have very serious questions raised. But on the other hand, I think that argues against the possibility that the court is going to go that broadly. I mean, after all, we have over 50 years of jurisprudence that have implicitly upheld the validity of independent regulatory agencies and what they do. And although in a legislative veto they overturned 50 years of practice, I don't necessarily see them overturning 50 years of judicial decisions, which they would have to do. So I don't see them going that broadly, really, but it's a possibility. Yeah.
The Senate has recently nearly approved a constitutional amendment on balanced budget. Would that not create similar problems in its implementation?
Well, it wouldn't create any problems of constitutionality, obviously, because it'd be an amendment to the Constitution, but workability, it would create a lot of problems. Definition, yes. And what becomes critical in that case is probably what role the courts would have in interpreting such a constitutional amendment. Obviously, it's the duty of the courts to interpret what the Constitution means, and when you have a balanced budget constitutional amendment, which is fraught with ambiguities and terminology that's not commonly understood or can be applied in many different ways, you open up the possibility of significant court involvement in something like that. But it would not be unconstitutional, obviously. Yeah.
What has been the history of balanced budget amendments in the state arena?
That's a good question. I think a significant number have them in their, either as part of their statutory law or as part of their constitutions, and that's frequently cited in the debate at the federal level. But as far as the numbers, I don't know. 40, did you say?
Yeah,
oh, yeah.
34.
Virginia has.
But they have a capital budget and a current budget.
Yeah.
Doesn't mean anything.
Thank you
Okay.
very much.
Okay. Thank you.